What's the subject?
I know. Number 16, item 16 says that, except for purposes of enforcement of this final judgment by consent, no part of this final judgment by consent, including without limit any statements or notices herein, shall be construed or admitted into evidence as an admission by GCACS in any other proceeding, and any such admission is expressly denied by GCACS. I think that's an example of some language in the document that is supportive of our situation and about our concerns regarding the future use of any admission of fault on this issue about procurement. I personally continue to have some deep concerns about signing this document for the long-term well-being of this school. And I can lay out some of my rationale for that. Some of those cases, some of the issues have already been raised here by parents and those attending tonight. One of my chief concerns is a statement earlier on in the document. And I will just find for you here, just a minute. Item 5 under section B states, as a result of the investigation, and this is an investigation of the facts related to the bidding procedure for the school, for the facility of the school. As a result of the investigation, the Attorney General determined that, and GCACS agrees, and agrees that GCACS did not follow the required competitive bidding processes for the design and construction of the structures of Blackburn Drive location, and that describes the location. I continue to have concerns about that statement, particularly in that it's a direct statement that we agree with the findings of the Attorney General regarding this situation. And I think there are a number of us who have serious misgivings and do not feel that in fact we did violate state bidding laws with regard to the procurement of this building and the facilities for the school. So from my study of this issue, and I've read the documents provided by the Attorney General and by our legal counsel, I feel that it's very clear in the actions that we have taken already that we are very clear in our commitment to making sure that we abide by the open bidding process from this point forward. Tony has attended numerous and in-depth trainings on that subject, and frankly our intention has always been to follow procedures. You know, in the early process of identifying the location for the school, we identified over 20 different locations in the city and considered those before settling on one downtown, which most of you know was a situation that didn't work out. And then we wound up working with Nick LaFada at this situation, and that had worked out very well in terms of our relationship with him. But there were, I state that, you know, for the record, to point out that we did a search for a number of sites. We followed a procedure that was not a closed process, and that was one that was certainly designed very much in the spirit of the actual letter of the law about the bidding process. So it's clear to me that we are very committed to that, and I hope that it's clear to everybody involved, including our state officials, that we are committed to doing that. and have taken steps to make that happen already. I'm very convinced that there are different interpretations of the circumstances surrounding this issue. I am not convinced, however, that we violated laws about this, the bidding laws. And I just want to point out a couple of points regarding the background to this situation. The Attorney General, in their initial letter to our legal counsel, in a letter of September 15th of this year, laid out their case against the charter school regarding this issue. And they went point by point through the procedure that we followed and the process that we'd undergone in doing this. And in their analysis on page 2 of their letter, they make a statement here that says the finding that GCACS has violated the competitive bidding laws and the designer selection law is guided by the recent Supreme Judicial Court's decision in Brazzi Development Corporation versus the Attorney General, and it gives the number of the case. So there's a clear statement in the letter addressed to our legal counsel that the whole process, or that the whole grounds for the case against the charter school is based on this Brazzi Development Corporation versus the Attorney General. And it goes into some explanation about that on page 3, about how that is so. Our legal counsel responded the next day in a letter dated September 16th in response to the Attorney General's office, stating what I have to read here. GCACS does not dispute that the Brazzi case now controls public construction projects. At the time of the lease for 2 Blackburn Drive, was entered into, however, Brazzi had not been decided. Indeed.
Well, in fact, actually, it had actually been decided by the lower court in favor of Brazzi. So, I mean, to me, that's really important. When I looked at this, I was thinking, wait a minute here. We signed a lease in March. At that time, as a point of law, it had been decided by the lower court in favor of Brazzi, the developer, and against the Attorney General. And it was not until May, 3 months later, that decision was appealed to the Superior Court by the Attorney General's office, and that the earlier lower court decision was overturned. But when I'm reading it, even though I wasn't here, I would go, if you're considering something, even as a point of law, whatever the precedent was at the time is what you would look to. I don't know what precedent says.
That's what I was saying. Just completing this thought here. The letter goes on to say, indeed, Chief Justice Marshall, in the oral arguments in the Brazzi case decided on May 10, 2010, well after the contracts in question related to Blackburn Drive were agreed to, he stated that the public construction statute, as written, quote, doesn't cover a lease, end quote. And that extension of the statute to leases would be an extension by implication. It goes on into discussing that further. It says Chief Justice Marshall's interpretation of the public construction statute on January 7th, 2010 was precisely the same as GCACS's at that time, when the 2 Blackburn Drive lease was being drafted. So we have a clear statement here that we're being expected to sign on to an agreement that states that we violated a state law that was actually defined and clarified after we ever entered into this lease agreement. So it's being retroactively applied to our case. And I have seen no explanation since then about why there is such a pressure to ensure that we sign a statement of our fault in this situation, and in this case.
You know, is it okay to jump in?
Could I just finish before? I'm sorry.
No, go.
Do you want to ask about that?
Yeah.
Piece? Okay, let's do
Because
that.
I thought that maybe Colin, did you say good time to cover that?
Sure. Yeah.
I thought that Colin, I'm not sure that the way Colin had it redone, that we're actually saying that we violated, because Joe Knowles might finish what you just read as a result of the investigation, the Attorney General, and we agree that we did not follow the required competitive business bidding process for the design and construction as described in the law. He might say, because they don't apply to release. So yes, we agree that we didn't follow those laws. I really think the question is, who said they were required for us? And in a way, there is no fault ever said in here, and the fact that we paper the record where they acknowledge that we set forth our positions in those letters of September 15th and 16th, all of that stuff you said in here, I'm not sure the question is, we ever are acknowledging fault that it does apply to a lease and that in fact we have violated that. We agree, we didn't follow it. It says we agree. I'm just saying that, I'm just not so sure that this is as bad as it was 2 days ago, where we really were.
Okay, so the language you feel has changed?
I think he's changed it, and you read it again just right now, because I stumbled through it. But GCASE agrees that we did not follow the required competitive bidding process as described in the laws. But again, Joe might finish that sentence because